Welcome to What Now? Health Reform in the Aftermath of the Supreme Court Decision. My name is Daniel Doan. I'm one of the associate directors at the Philip R. Lee Institute for Health Policy Studies here at UCSF, and I'm going to be moderating today's panel. Yesterday, the court issued a 5-4 opinion authored by Chief Justice Roberts that upheld most of the Patient Protection and Affordable Care Act of 2010. The Affordable Care Act, also known as Obamacare, or by its initials ACA, passed in dramatic fashion in 2010. ACA is a complex piece of legislation that aims to reform both health insurance and healthcare delivery. The court's decision on ACA has often been cast in the context of presidential politics. Would the justices side with the Democrats or the Republicans? Does their decision represent a win for Obama or for Romney? Today, our goal is to go beyond the political scorecard. As health policy analysts, we want to delve more deeply, to understand the court's decision, and to consider how Obamacare may be implemented in light of the court's ruling. We have 4 distinguished panelists to guide us, and I'll introduce them in just a moment. But first, I want to recognize the sponsors of this event: the Philip R. Lee Institute for Health Policy Studies, the UCSF UC Hastings Consortium on Law, Science, and Health Policy, and the UCSF Pathway to Discovery in Health and Society. I also want to thank Jessica Machado, Jay Sullivan, Ernestine Florence, and Eunice Chi from IHPS, and the UCSF Public Affairs Office for all their hard work in bringing this event to fruition. Now let me introduce our panelists and turn things over to them. Each will speak for about 10 to 15 minutes, and then we'll have plenty of time for questions and discussion. So first up is David Faigman, the John F. Digardi Distinguished Professor of Law at UC Hastings, and the Director of the UCSF UC Hastings Consortium. David's an expert in constitutional law, and he helped us understand the constitutional basis for the court's ruling. Jaime King is Associate Professor of Law at Hastings and the Associate Director of the Consortium. Jaime holds a PhD in health policy, and she will interpret some of the key points in the ruling and the legislation as they relate to health law and policy. Andy Bindman is Professor of Medicine, Health Policy, and Epidemiology and Biostatistics here at UCSF. Andy's one of my faculty colleagues at the Institute, and he was a Robert Wood Johnson Health Policy Fellow in the U.S. House of Representatives when the ACA was debated and passed. And he continues to travel regularly to DC to consult on its implementation. So Andy will bring an inside the Beltway perspective on the politics and policy of Obamacare. Finally, Josh Adler is Chief Medical Officer of the UCSF Medical Center and the UCSF Benioff Children's Hospital. Josh brings the perspective of a healthcare leader. He'll discuss ACA's impact for providers and systems, including how ACA may impact academic centers such as UCSF. Again, thank you all for coming, and I'm going to turn things over to David to take it.
Thank you, Dan. It's great to be here. I decided to stand up just because when you're teaching or talking about the Constitution, you ought to expand as much as you can to fill the room. First of all, it's a good day for the United States, a bad day for constitutional scholars, and I'll explain why that is the case. So the outcome is wonderful. The case itself is something of a mess. In fact, one of my constitutional law students from last year wrote me an email, and he said, "I'm very glad that I graduated this year, so I do not have to learn the ACA case." So just in terms of constitutional doctrine, it's really an open question of where things are. At page 42 of Chief Justice Roberts' opinion for the court, he quoted a letter from Benjamin Franklin, in which Franklin wrote, quote, "Our new Constitution is now established, but in this world nothing can be said to be certain except death and taxes." The short of the opinion is that the federal government has power over taxes, but not over death. So that's a takeaway line from Ben Franklin. The name of the case is actually National Federation of Independent Business versus Sebelius, although I think it will forever be referred to as the ACA case. And in the case, as Dan pointed out, the court upheld Congress's power to impose an individual mandate Also upheld Congress's power to expand Medicaid, but subject to certain limitations. My job here today is just to kind of go through the case itself, give you the basic highlights. Many of you probably have a sense of it already, so I'll go through pretty quickly and maybe offer a few comments or maybe a few snide comments. There are three essential parts of the decision. The first essential part concerned what's called the Anti-Injunction Act. The Anti-Injunction Act was an 1867 law that provided that a tax could not be challenged until after it had gone into effect and the party that had standing had either paid or refused to pay the tax. So if that had in fact applied, the court would have dismissed the case would have been over, and it could not have come back until 2015 when you owe taxes for 2014. In short, the court held that Congress did not intend the payment, which was called a penalty in the law, in the ACA, to be treated as a tax for purposes of the Anti-Injunction Act. The Act itself describes the provision, as I said, as a penalty, not a tax. What, of course, is quite interesting, perhaps ironic, is that the Chief Justice finds later that the law is to be upheld under the Constitution as a tax, but it is not a tax, it is a penalty under the Anti-Injunction Act. So how it can be not a tax in Part 2 of the decision and it becomes a tax in Part 3 of the decision, that is the reason you go to law school. That is what you learn to sort of suffer ambiguity, and that's why my student, his name is Ryan Murphy, is glad that he is now out of law school. The second issue, the big issue, concerned the so-called individual mandate. The individual mandate had been challenged as beyond the powers of Congress to enact. In fact, Chief Justice Roberts begins his opinion. For anybody who's thinking of going to law school, I do recommend Part 1 of the decision because it's essentially a civics lesson on the relationship between the federal government and the states. The government argued principally that it had the authority under the Commerce Clause of the Constitution, buttressed by the Necessary and Proper Clause. The Commerce Clause and the Necessary and Proper Clause are both part of Article 1 of the Constitution, actually Article 1, Section 8, which describes the powers of Congress. As you all will remember, for those of you who are not lawyers, from 8th grade, that our government, our federal government, is a government of enumerated powers, and therefore the Congress has to specify where it gets its authority from. And so the federal government, referred to as the government, basically claimed that its authority came from its power to regulate interstate commerce, and the Necessary and Proper Clause actually buttresses that power, and it gives the federal government all reasonable means necessary or proper to carry out that power. Alternatively, the government argued that it had the authority to pass the individual mandate under its broad taxing power. So under Article 1, there are a list of powers like over navies and armies, commerce and coining money and so forth. But there's a separate provision that actually gives the federal government the general welfare power over taxing and spending. So this one case, it's a wonderful case for people who teach constitutional law in one sense, because it presents some of the major issues of constitutional law in the beginning, because there was a Commerce Clause problem, which is huge, but it was also a taxing and spending problem as well. We'll get to the spending when we get to the Medicaid expansion. Chief Justice Roberts found that the commerce power did not authorize Congress to require individuals to purchase health insurance, but that the taxing power did authorize Congress to lay and collect taxes on those who failed to purchase health insurance. Once again, and I was playing golf the other day, and somebody came up to me and said, well, explain to me how you can have the power in one area but not have the power in another area, but you're essentially doing exactly the same thing. And I again said, well, you need to go to law school to understand that. It's not that you actually understand it after you go to law school, but you're willing to suffer not understanding it. So I don't actually understand it. Chief Justice Roberts doesn't actually understand it. But as long as the system keeps moving forward, we're all more or less willing to accept it. In short, the theory of the Constitution is, as I said, the federal government is a government of enumerated powers. So the government did have to specify where it was getting its power from. Moreover, the court has to specify where it thinks the Congress gets its power from, and they relied on the taxing power. The Commerce Clause, Roberts wrote, did not give Congress the authority to create commerce, but only to regulate commerce that already exists. This argument relies in part on a somewhat technical distinction in constitutional law, which has been described as the activity-inactivity distinction, that historically Congress had the power to affect activities. In fact, the rule says that Congress has the power to regulate activities that substantially affect interstate commerce. And so the argument was that buying health insurance or not buying health insurance is an inactivity and Congress doesn't have the power over it. I have to say, prior to the ACA actually being passed, most constitutional law scholars thought that that was a laughable argument, this sort of Tea Party argument that activity-inactivity made a constitutional difference. Most of us would have thought it was fairly ridiculous. If one of my students had made that argument on an exam, they probably would not have done very well. But it really got traction, it got resonance, and whether it was through the megaphones of Fox News or whatever, somehow, and some constitutional scholars like Randy Barnett advocated that position. If you want a very exacting and rigorous and brilliant treatment of why that is ridiculous, you really ought to read Justice Ginsburg's concurring opinion and dissenting on the Commerce Clause issue. It may be the most brilliant opinion that she's written while she's on the court. She's written some, like United States versus Virginia, which was the VMI case, but it's really a wonderful piece of scholarship. Among many of the ironies in the case, which we can get into in the discussion, again, from a constitutional matter, Roberts takes a highly formalistic approach to the Commerce Clause. So he basically says that when you look at the specific form of the Commerce Clause, it doesn't extend to give Congress the authority over the individual mandate. Yet, under the taxing power, he adopts a different constitutional methodology, which is called a functional constitutional methodology. So in the different parts of the opinion, he's actually using two different constitutional methodologies, which again would be a red X on when I'm grading exams. So you can see, I don't think Chief Justice Roberts, I think that the outcome was a wonderful outcome, but I think Chief Justice Roberts did not do very well in writing the opinion. Next, Roberts considered whether the taxing power provided the alternative basis, and he said that it does. He argued that unlike the Anti-Injunction Act, which is a statute, the question of whether the tax penalty provision enforcing the individual mandate was a permissible tax under the Constitution, and that that question is a constitutional question, not a statutory question. So really the difference and the explanation for why in Part 2 of the opinion it's not a tax for the Anti-Injunction Act is because it's a statutorily defined question of whether it's a tax or a penalty, but under the issue of whether the Congress has the authority under the taxing power, that's a constitutional question, not a statutory interpretation question. On the statutory interpretation question, the court is supposed to be deferential. The court is supposed to be deferential to Congress. On the question of the Constitution and the interpretation of the Constitution, the court is not supposed to be deferential to Congress. Couple of snide comments. As I said, the opinion itself is a bit of a mess. As I also said, as a constitutional matter, the opinion doesn't hold up in terms of constitutional methodologies being formalistic and then functional. And then one I might ask, how did Roberts end up writing this? I am luckily on the record for thinking that the court was going to uphold this case. In fact, I thought that Roberts would be the deciding vote. Chief Justice Roberts wrote a case called United States versus Comstock, which many of you in the room who are in psychiatry will recognize, that upheld the Adam Walsh Act, which allowed the federal government to civilly commit former federal prisoners as sexually violent predators. Roberts read the Commerce Clause very expansively in that case. Justice Kennedy, on the other hand, which a lot of people thought that Justice Kennedy would be the swing vote, Justice Kennedy is the swing vote in lots of cases. He is not the swing vote on federal and state power. He consistently rules on the side of state power. He has a very 19th century notion regarding the relationship between federal and state power, and he's almost always on the state power side of things. The other point that I would make that is just pure speculation is that I think Chief Justice Roberts wanted to be on the right side of history. And on the issue of expansion of federal power in our highly interdependent nation, the past, at least since 1937, and the future is one of federal power. And quite frankly, I think Chief Justice Roberts was worried about his legacy. I think if he had joined the dissenters, the joint dissent, he would have been perceived, it would have become the Roberts Court, and it would have been put in the same basket as justices like Chief Justice Roger Taney, who of course decided the Dred Scott case, Justice Peckham, who decided Lautner versus New York. It would have been perceived as a purely political outcome, and I think that it would have shed really disrepute on Chief Justice Roberts' legacy. So I think that when push came to shove, there's even been some suggestion that he changed his vote in the months just prior, and that wouldn't surprise me, especially reading the joint dissent. The joint dissent is actually an interesting animal itself. Typically, justices write dissents that are joined by other justices. This was a dissent that was signed by all four of the justices in dissent. It reads like Scalia wrote it because it's extremely snarky. And so pretty sure that he wrote most of it, and he also throws out lots of Latin terms that we don't so much use anymore, except when we're around medical school audiences. So it looks like we know something. And rarely do they all sign the opinion in that way. So that's unusual. Finally, I'll finish up, and I know that my colleague Jaime King will get into this more. The final issue is the Medicaid expansion. That's a spending clause problem under constitutional precedent. The rule is, it's a case called South Dakota versus Dole, but the rule is that if the federal government commandeers the states or coerces the states to become agents of the federal government, that's unconstitutional. And there were actually 7 members of the court that found that depriving the states of all of their Medicaid funds for failure to expand Medicaid was unconstitutionally coercive and would effectively commandeer the states into the federal apparatus, and that was unconstitutional. However, they limited the reading of the statute to say that a state would forego its Medicaid money if it failed to expand, which of course we're talking about tens of millions of dollars. So every expectation is that will still be coercive, but it will be constitutionally coercive, so that's okay. So I'll end there, and I'm more than happy to, and I look forward to answering your questions. Thank you.